direction, and our position on that is that if council is unhappy with the directions you've just given, he knows what to do. We have spent far too much time running away from the business of the day. This matter was certified urgent several days ago. It seems on the 9th of October that when the applications before you were certified urgent, we came here, the other side scuttled the date when we came with what turned out to be a frivolous issues about to empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Kerugoya, whereas the court in Kerugoya fixed a date for the application now before you, it did not fix a date for the application. Now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were to hold, my lord, we too, the party representatives, filed a PO, and you've not heard me telling you.
On record, in view of the holding in the Supreme Court case of...
When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court,
we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senior Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima, and my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, appeal. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and two others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
Counsel, we don't use that kind of language. I think Senior Counsel Paul Mutu is right that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed, applicants.
My Lord, I was on my feet. This is on behalf of the petitioners on the issues of time allocation. My Lord, the respondents have, throughout this matter that has been going on, to guard before
the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been that it is necessary for them to do fair representation within the issues. The petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they are not enough, we will consider. We're here. We shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish. The problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
My Lord, may I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongoya, please sit down. Let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you so much, my Lord. That's an impressive direction.